Well, good morning, everyone. Thomas Montgomery here. We get together with our distribution partners most weekday mornings at this time, 8 o'clock Central, via Zoom. We talk strategies, tips, techniques, and we're here to support each of you. Typically, when we're talking about our distribution partners, we're talking about our white label partners, and there's two types of white label partners, isn't there? Those on the access to capital side, and then those on the 60-day credit suite. But we'll group them together for a moment. So we have our white label partners who are going out to the marketplace under their own umbrella, their own branding, their own pricing. And so that is category one of our distribution partners. And then we have our referral partners. However, there truly is a third group, and there's, of course, some overlap. And our third group is what we call our debt buyers. So let's talk a little bit about debt buying in terms of what it is and why it's important, and how it may very well be an important role that many clients can use to improve their credibility. So we'll start on the left-hand side here. So back when I was with the SBA, we put together the concept of this, and then we officially launched it just earlier this year, and it's called the Collateral Support Program. So let's step back and talk about why this is relevant. So if a small business, or I guess any size business, is looking for funding to start to grow, to reach their potential, one of the earliest decisions that they need to make is, do I want to go after debt, or do I want to go after equity-based capital? Debt is money that we borrow and agree to pay back. Could be loans, lines of credit, revolving trade lines, what have you. Or then equity-based capital is money that we don't have to pay back. So it's an investor injecting capital in, not with the expectation of being paid back like a lender, but instead sharing in future profits. If a small business or any type of business is wanting to use debt as a capital raise tool, then of course we have to be cognizant of the 3 C's: credit, cash flow, also called capacity, and collateral. Now, idea in what you and I learned in schools, you really should try to have all 3 of the C's. That's going to give you the most access to capital. However, we certainly need to have at least one of the 3 C's, either enough credit, enough collateral, or enough cash flow. And then there are some lending options available if we have just one of the 3 C's. What we often see with our clients is that they come through and they have what's called a collateral shortfall. So that's the role of the collateral support program, and I'll advance it down. So the collateral support program is a legal and effective way where we're transferring assets over to the balance sheet of the client. Now they have adequate collateral, so we've eliminated the collateral shortfall, so they're able to check that box in terms of credibility on paper. Well, why does collateral matter? Well, think about it. If you were a lender, if you're lending money to someone, you would like, first, you hope and pray that they'll pay you back. But if they don't pay you back, it's certainly wise to have something to attach to as collateral. So when you finance a house, there's a lien against the house. When you buy a car and you finance a car, the car is the collateral. But when you get into working capital loans, a lot of times small businesses don't have enough assets on their balance sheet. So the collateral support program fills that gap. But there's the whole other side of being a debt buyer, because maybe that's not what we want to call ourselves, but that's technically what's happening. We're buying receivables and putting them on the balance sheet of the business. So that means that we are becoming a debt buyer. So let's step back and talk about the debt buying industry. The debt buying industry has been around for quite some time, but it's usually been a playground for the rich. They would buy portfolios of defaulted mortgages, defaulted credit card debt, and or defaulted auto loans. They usually buy those for pennies on the dollar, and then they seek to liquidate those. So they're buying those assets to make money. So what's interesting here on the left-hand side, when you and I are working with small businesses, The collateral support program really provides two benefits, one of which is to alleviate the collateral shortfall by putting true assets, true receivables on their balance sheet, as we said, but also now they're a debt buyer, and then we should seek to liquidate the debt. While AR is real and it's an asset, no logical small business owner would seek to have only AR unless the goal is to move AR, meaning accounts receivable, unless our goal is to liquidate that AR and turn it into cash, right? If you and I went and started a lawn mowing service and we went out and we got 10 contracts from 10 homeowners or small businesses to do their yards. So we got the contracts, we know we're owed the money. Is that our ultimate goal? No. It's to convert that into cash, to collect money off of it. So that's what we're really talking about today, is a new way to liquidate receivables. Now, the collateral support program is typically used, as I mentioned, by small businesses looking to resolve their collateral shortfall, but increasingly we're having individuals, often more sophisticated individuals, coming to us wanting to buy portfolios of debt, not for the purpose of building their balance sheet alone, but they want to use it as a cash flow tool. I've told you many times, our largest debt sale that we've made is to a large law firm out of Austin, Texas. They bought millions of dollars of debt. Did they buy it to fluff up their balance sheet from this left-hand side perspective? I don't think so. They didn't disclose that, but instead they bought it for pennies on the dollar, and then they litigated to bring in more money than they spent. Because ultimately, what should we all be looking to do? We should all be looking to grow our wealth. There are different ways to grow wealth. Some of you are very active in real estate, and so that's fine. You could buy and hold or buy and flip, whatever you'd like. Some of you have tried your hands in cryptocurrency. You can just play the stock market at large. But I think what you'll see here is that using this 1-2 punch of the collateral support program and then following that with our liquidation program probably offers greater upside with less risk and more predictability. So what we're going to do is spend a few minutes and talk about the new debt buyer contingency-based litigation program. Again, this is relevant to those of you who are already debt buyers, are already with us. You already have a portfolio or multiple portfolios, but it very well could be relevant to others that are looking for an innovative way to grow money. So let's go through it. So first, we define what a debt buyer is, because of course this PDF might have been read without this accompanying discussion, but we'll just go off the sheet for now, even though it's a bit redundant. So debt buyers buy delinquent or charged off debt at a fraction of the debt's face value. Now let's dig a little deeper. So understand, when we're buying debt, we're buying what we would call a non-performing asset. So in other words, there's a debtor, someone that owes the money, but they're not paying as agreed. If they're paying as agreed, then that would fall more into AR financing or even factoring. So that's a bit of a different instrument. That's a different beast. What you and I are talking about here is non-performing debt. The debt buyers truly owe it. It's really theirs, but they're not paying as agreed. Therefore, it is purchased at a fraction of the value, typically around 10 cents on the dollar. So once we have that debt, if you and I decided, well, this makes sense. I want to be a debt buyer. I want to make money by buying and selling debt, or buying and collecting off of debt. You'd have to say, well, how am I going to liquidate? So not litigate, but liquidate, because we need to move that AR into cash. And there's actually several different strategies, and it's not really part of the sheet, but I just want to give you a broad overview. So if you have receivables, whether it be your own organically, or if you purchase receivables like through the collateral support program as a debt buyer, one option would be just simply to collect the money. And you could just collect internally, just send them an invoice, say, hey, Joe or Susie, you owe me money, why don't you pay? And so that's a reasonable thing to do. And we could even use third-party debt collection companies. Here's the problem with that option, though. We've already disclosed that we're dealing in this model with people that are already delinquent and the debt's already charged off. So because of that, that would mean that they're not paying as agreed. And if they're not paying as agreed, simply reporting them to a collection agency who will make the calls, send the letters, and most often report them to the credit bureaus probably won't be effective, because they've probably gone delinquent or charged off other debts too. So they're what we call a credit roach, people that have bad credit and they don't care, or they'll just use credit repair to erase it off. So one way to liquidate debt, AR, is to collect off of it. But we've already disclosed we're probably at a disadvantage there, because these folks haven't paid their bills in the past. What makes you think they're going to start paying in the future? Another option is to buy low and resell. So resell the debt. So that is an option. And then what we're going to talk about today is the concept of litigation, which is our preferred approach. And so why did the law firm in Austin buy millions of dollars of AR? Because they want to collect their money, and they're going to collect it through litigation. Historically, litigating debt, whether it be our own internal organic debt, let alone buying debt to liquidate, has been a barrier, because there's only a small number of law firms that'll do that, and many of them want to charge an hourly rate. We've seen $250 to $350 an hour typically, plus you have your court filing fees. So could it still add up? Could it still make sense? Of course it could. But if you look at what Capital One, let's take Capital One. We've all heard of Capital One, right? What's in your pocket? We see the advertisements. And so they work both in subprime and prime space with credit cards and auto loans and such. They're one of the biggest litigation programs in the country in terms of pursuing bad debts. So litigation is a proven model of liquidating debt, and it's almost guaranteed, because these folks have breached their agreement. If they foreclosed on the house, then of course that is collectible. If they defaulted on their auto loan, of course, then that's collectible. If they've defaulted on credit card debts or other types of professional services, it's a breach of contract, and the chances that the debt buyer would win the lawsuit through litigation is nearly 100%. Now, I'm only a paralegal, I'm not an attorney, so I can't give legal advice, but here's just a little tip. If someone is sued for a breach of contract, which is the concept we're talking about here, how is it that they could not be responsible to pay for it because they breached the agreement? Well, they would have to come up with some sort of defense. And we're not talking about criminal defense, we're talking about civil. They'd have to have some defense of why they don't owe it. And it's remarkably rare in a well-prepared case that they can come up with a defense of why they don't owe the money, because they breached the agreement. And we'll talk about some of the strategies to collect in a moment. So the bottom line is it's nearly 100%. Whereby if you send all these files to a collection agency, the collection agency might do their work and call them and harass them and report them. But does that mean they're going to pay? Because the goal here is to get the money, right? It's not to make anyone's life uncomfortable or miserable. It's to move the AR into cash. All right, so then the next question is, well, why is debt buying so profitable? As I alluded to, litigation, which means suing the debtor, is a very successful strategy to liquidate, meaning collect 100% or even more of the principal debt, and I'll give you an example in a moment, owed in addition to late fees and court costs, resulting in an extraordinary ROI, return on investment. Let's just use a simple example here and look at the numbers. So let's say that we have someone that is, let's say they're one of our white label partners. So they sign up and then they breach the agreement. They don't do what they say that they'll do. So that white label partner now is the debtor. and they would owe, according to their agreement, $10,000. It's a license fee, and the details didn't matter here. But the bottom line is there's just no question that there is a breach, and there's no question that the amount owed is $10,000. Well, if a debt buyer were to buy that for pennies on the dollar, that's good. They could litigate and they would collect 10,000 one way or the other. And we'll talk about some of those steps as we scroll down. However, it gets better than that, because a well-written agreement not only will allow the debt buyer to collect the principal, in this case, the 10,000, but also daily late fees or interest. Now, in our model, our agreements use late fees because they can accumulate much quicker. There are certain statutory limits of how much percentage interest rates you can charge, but there are no constraints on daily late fees. So think about that for a moment. So the debtor, here we're just using an example of a defaulted white label partner. They didn't perform, so they owe the 10,000. They get the invoice, and then every day that goes up by $50. So let's assume that there's an average of 30 days in the month. I know some have more, some have less, but now that balance increases by $1,500 a month. So look at that in the eyes of a debt buyer. Where could you go buy? Where could you go take your money, whether it be real estate, cryptocurrency, the stock market, and look at it grow, in this case, 15% per month? In today's economic environment, if your money grew by 15% in a year, you're a rock star. Here, it's growing by 15% per month. 15% per month, legally, ethically, not a Ponzi scheme, not buying oceanside property in Arizona. This is real, contractual obligations. So then how long do those late fees go? Well, from the time of invoicing up until the court date. So one of the things that we do when we litigate is we're going to revise the petition to the court as that money grows, because we want the debtor to capture 100% of what's owed under the agreement. But we're just going to assume that it takes 2 months to get on the court's docket to go to court. So 2 months of 1,500 is 3,000 plus the principal. Now we're at 13,000. And remember, the debt buyer paid pennies on the dollar for this, pennies on the dollar. So their return on investment is just freaking exponential. So the amount of 13,000 or more can be collected off the original principal, the 10,000, which is normally purchased for around 10% of the principal amount, which we mentioned. So the ROI is just crazy. So using this model, debt buying has a far superior profitability opportunity than real estate investing, flipping, gambling on the stock market, or cryptocurrency, with less investment and risk. So let's stop here. There's more to go through. Does anyone have questions on the material that we've covered so far? Because it's important to understand key terms. What is a debt buyer? Understanding who a debtor is. Understanding the principal amount, which we just gave you an example, and then talking about the just nearly exponential growth. Now, a number of you are financial advisors and CPAs that we have on here. And when you look at this, it's like, wow, I mean, where else would you find a place that your money could grow quicker? I don't know, not legally at least. Okay, if you have any questions, comments, concerns, post it in the Q&A there. It's like chat box on Zoom, and I'm going to continue. So we've covered what a debt buyer is and why it's so profitable. We're looking at the numbers. Again, each debt instrument may be a different amount. I'm just using an example of a defaulted white label partner, but of course the amounts can be bigger or smaller. However, the daily late fees are consistent, so the actual percentage growth goes up as this goes down, but that's just a mathematical equation. So let's scroll on. All right, page 2. There's only 3 pages, so don't worry, we're almost done. What is the economic proposition to the debt buyer? So again, we've already talked about, typically we're using these debt instruments to overcome a collateral shortfall, right? That's why the collateral support program was developed. but now we're recognizing, in addition to having the assets in the balance sheet, now we have the ability to earn an extraordinary return on investment. So we talked about there's a couple different ways to liquidate. We could use collection agencies or even do in-house collections. That tends to not be very effective from our experience with people that are not paying their bills. They don't care. Litigation is typically where debt buyers will go. And so there's different types of litigation. As I mentioned, many law firms will charge hourly, as we've talked about, but there's some firms that are contingency-based, and that's really our focus today, is to talk about contingency-based litigation. So it's just like a personal injury, right? If you were in a car accident, you could find a contingency-based law firm that wouldn't charge you anything. They're just going to take a chunk of the proceeds. So it's great. You have no out-of-pocket expense. So here we're talking about the litigation firm will assume all upfront cost of filing the suits. There's a lot of time and money that goes into filing these suits. And we'll talk about the process here with these bullets in a minute. And then once the lawsuit is won, which it's almost always won, it's very difficult to lose a breach of contract case if you're properly prepared. Then we also have to then collect the money. Because frankly, just because you win the lawsuit against someone doesn't mean that they're going to just hand over the money before they walk out of the courtroom. The truth is 80 to 90% of people never show up for court, so you win a default judgment, but that's an aside. So what we've put together with Business Paralegal is an innovative contingency-based litigation offering to debt buyers. So this is meant to be a resource for those that are using the collateral support program for assets in their balance sheet. If they've not been successful in liquidating the AR themselves, then they could use this model as well as to others. So in our model, we are not asking for any upfront cost. We cover out of our pocket all the legal expenses to file and handle the entire litigation process. So just to go file hundreds or thousands of lawsuits as we do, it's expensive, right? Because you have to pay the courts to file, and then you have to pay to serve the people. And so we absorb all of that. We don't pass any of that on. There's just no upfront cost to the debt buyer. And then we just simply split the proceeds. So if we go back, well, what would that mean? Well, so if we have a debtor, let's say we have a white label partner that went south on us, 10,000, let's say it took us 2 months to get it on the court's docket, we're going to win. We'll win every time. So 13,000 is now owed. And so the debt buyer is going to get half, and then we're going to get half for doing the work. Let's talk about all the work that goes into it then. Again, if you have any questions, comments, concerns, feel free to post it into the Q&A. That's why we're here. So what is the typical litigation process? We're going to have to decide venue. And so all of our contracts are written for Wood County, Texas. And that's obviously a strategic advantage for us because it's our backyard. We know the court system. And frankly, it's not all that convenient to others. We petition the court to not do Zoom, to not do telephonic hearings. We petition to do everything in person. And so there's an advantage, right, of having venue, because now people, if they want to respond or fight the case, they have to come to rural East Texas. So we do have to decide venue, and we also have to just decide jurisdiction. So are we going to go through small claims court? We're going to go through state court, or we go through federal court. But regardless, once we've decided the jurisdiction and the venue, we're going to start the process, and we're going to start with a demand letter. And so the demand letter is just clarifying you owe a debt. We want to resolve it. We don't want to sue you. We want to resolve it. And if you don't resolve it, you're going to court. And so the demand letter is the first step, typically in the litigation process. I sent out a demand letter yesterday to a wonderful lady named Maria. And she's like, well, I don't want to go to court. Well, you breached the agreement, right? So either make arrangements to come to court, go hire a law firm to come represent you in Wood County, Texas, or just do what you said that you would do, Maria. It's that simple. People that that break their agreements, that breach their agreements, they almost always have an excuse, right? Well, my granddaddy had COVID back in November, or whatever excuse. It doesn't matter. If there's an agreement, it's enforceable. So the demand letter goes out first, and then we have to develop the court citation, the petition. And so depending upon which of the courts, the format can be different. Some courts allow e-filing, some are only paper-based, some like faxes, some don't like faxes. So we've got to get the court citation created. And then that has to be filed with the court. And then what's not mentioned here is then the debtor needs to be served. And that's very powerful, because as we talk about this, our goal is never to sue people, it's to collect the money, right? You as the debt buyer want the system to work so you get your money, right? And so that's all we want. And so what can happen is at different points during this process, it could be the trigger where someone says, like Maria yesterday, I think she's going to come back and pay today because she doesn't want to go to court. So sometimes just the demand letter will get someone to say, oh, I don't want to go to court. Because what happens? We'll negotiate and usually waive late fees or waive some of the late fees. So it becomes cheaper for them. It's better for them. Because if they fight the case, they're going to almost certainly lose. They're going to have a ton of late fees, and they're going to have to absorb the court cost. And there's a hell of a lot of work involved on their part, which we'll get to in a minute. So the point is, each of these steps is a trigger that hopefully will motivate the debtor to pay either in full or make payments. So we talked about developing the court citation and then filing it with the court. Then the individual has to be served. There's different ways to serve. The most common is the sheriff. So the sheriff walks out to your door at 8 o'clock in the evening, knocks like hell on the door, scares mama and the kids. And everybody's asking, Daddy, why is the cops outside? And they're there to serve. You're being sued. A strategy we really like is to have people served at work. So if they're employed by others, nothing more powerful than their supervisor, their manager, watching the sheriff's department show up to serve them. So bottom line is the citation has to be developed, has to be filed with the court, and then individual has to be served. Now, some people will try to elude service, but there's ways to circumvent that. So they'll be served either directly or indirectly. So now we have a debtor that's on notice, and now we're moving through the court process. What you and I know is that cases are typically won or lost in the discovery process. Many attorneys and litigation firms, in my opinion, respectfully, are lazy when it comes to the discovery process. We have spent thousands and thousands and thousands of dollars with law firms that have helped us with lawsuits. Great people, but again, I typically see a lack of aggressiveness, a lack of a strategic approach to discovery. So let me tell you how it can be done more aggressively, but legally, of course. So we want to request written depositions from the debtor. So this is information that's relevant to the case, nothing punitive, nothing to waste their time or waste the court's time, but now there's effort being put in. What happens if the debtor doesn't respond to these different discovery requests, including the written depositions? One of two things. They either could be sanctioned by the court, which could mean they go to jail or be fined, lose the case, or worse. So written depositions are part of a common discovery process. Another is request for production. We need to look at their bank statements, their emails, and the way that we request emails is what we call the FTC model. It's not just, hey, send us your emails, print them out. There's technical requirements that, unless they're fairly sophisticated, is just a pain in the ass to put together. But again, it's legal and it's part of the discovery process. We probably are going to need to see their text records and even their cell phone records. So requests for production, and these could vary, but the bottom line is that is helpful for our case, and it's a pain in the butt for the debtor. It takes time and energy. Again, that might be another reason they'd say, all right, I realize I breached the agreement. Let's just settle, right? Because that's the goal, is to get you the debt buyer the money. It's not to take people to court. Interrogatories are a list of questions, and in Texas, we can ask up to 25 of those interrogatories. And so those can be very strategic and frankly, can be uncomfortable. One of my favorite sources of discovery are requests for admission. So those of you that are attorneys or paralegals like myself, you understand the power of requests for admission. So you're able to ask typically an unlimited questions, and they have to admit or deny. So we'll just role play here. We'll take Joseph, who's one of our top white label partners. So we could ask Joseph, admit or deny you've ever used an illegal substance. Joseph, admit or deny that you've ever had an extramarital affair. Joseph, admit or deny that you've ever looked at porn. And so all of a sudden, it just becomes a pain in the wazoo for the debtor to respond to these. Now, it needs to be structured as such where it's relevant to the case. But my goodness, you can see that this process is just incredible. We can also do oral depositions, and that's where we can typically spend up to about 80 hours in a room in Wood County, Texas, asking question after question after question after question. So what does that do to the debtor? Takes them away from home, takes them away from work for 1 to 2 weeks. They're typically going to have an attorney that they're paying, what, $300 or more an hour. And so it doesn't make sense for the debtor to defend a breach of contract suit, which they're clearly going to lose. It's just a money pit for them to spend time defending it, because they're not going to win it. They're not going to win it. They're not going to win it. And so again, what's the goal? To get the money to the debt buyer, to get the money to each of you that's using this. Once we get through the discovery process, we have the data set we need. So now we're going to prepare for trial, and then we're going to have actual trial. Trial is interesting. Trial can be remarkably short. We have one day coming up on the court docket. We have 12 cases with the same court, 15-minute increments, because the judge knows it's a freaking slam dunk, right? There's nothing, probably nothing, that the debtor is going to say that's going to keep them from losing that breach of contract suit. So the judge set them up 15 minutes, 15 minutes, 15 minutes. Think about it. How much time is 15 minutes to have a court case? I'm not talking about a hearing to talk about something. We're talking about the whole court case. 15 minutes, 15 minutes, 15 minutes, 15 minutes, because it's a slam dunk, my friends. It's a slam dunk. So then once the victory is accomplished, then of course the post-judgment collections. All right, questions that we get often from our debt buyers would be questions like, well, how long does this process take to get money, right? Well, if you're using the collateral support program to add assets to your balance sheet, of course, you're getting that benefit immediately. But in terms of liquidating, you have to remember, our goal is not to sue people. It's to collect the money that's owed, to you, the debt buyer. And as I gave examples of, therefore, each step in the process has a good chance of triggering the person to want to pay rather than to continue, because they're going to lose. They're going to lose the case. Why would they want to? Why would any logical person want to spend more time and more money to defend something that they're going to lose? It makes no sense. Now, some people will just hang it out, right? They'll say, oh, it's a matter of principle, and I'm going to go through this process. Well, okay, then you're going to go through all of this. You're probably going to need an attorney. You're probably going to spend anywhere from $12,000 to $36,000. And then, of course, the debtor is paying their legal fees, and we're going to sue them for our legal fees too, right? So it just, why would you want, in this example, to default on a white label agreement for $10,000 and be into it for $50,000, right? What logical sense does that make? It doesn't. So the point is, how long does it take? Well, we don't control the litigation process, but the goal is to collect the money owed, and each step could be a trigger. That's the answer to that question. Once we go to trial and we get the judgment, which we should always do it, then we have to collect the money. And so some people think, oh, I'll just sue someone and I'll win, and oh, everything's fine. Well, the money still has to be collected. And so there's a certain skill set in locating and collecting assets. Sometimes people will try to hide or fraudulently transfer those assets. We have the means to track those down, and they can go to jail for doing that, by the way. We can put liens on their property, their businesses, their homes, so forth. We can do writs of garnishment, where we just literally, with the court's permission, of course, yank that money out of the account. Nothing worse than waking up in the morning, looking at the bank account, and it is freaking bone dry. And that's what we're going to do if they owe the money and they lose. We can seize and sell the debtor's assets. We can also garnish their wages, which isn't listed here. And even if they're fairly low income producers, we can normally still get 25% of their wages. We can get turnover orders, which if the debtor refuses to comply, they could be held in contempt of court and go to jail. And so there is no debtor's prison. You could owe someone money and you wouldn't, it's not a criminal event, it's a civil event. But if you don't comply with the court's orders, now it's criminal and go to jail. And then we can, of course, handle the filing of the motions to compel or contempt if they don't comply. So you might say, well, wow, this sounds pretty powerful. I can see how the collateral support program can put assets on the client's balance sheet. I'm starting to see how this model can work to be able to grow money by being a debt buyer. The question becomes, what do I have to do? If I want to be a debt buyer, how much am I involved with this? Because most people don't want to be yelled at or cursed at or receive profanity, because once you sue people, they just get freaking ugly. They'll say things about your mama and your kids, and they'll threaten you, and it's ugly. It's ugly. And so that's the nature of what we do. I suspect most of you wouldn't want to take those arrows. So we developed this to be a turnkey program for debt buyers. So there's really nothing that the debt buyer needs to do. We're going to have the paperwork to assign the debts to us, so everything's legal and compliant. As a debt buyer, they're not interacting with the debtors. In fact, not involved with litigation, and usually the debtors won't even know who the debt buyer is, so they're invisible to the process. However, the collateral support program purchase has to be completed, so this doesn't make that go away. And as I mentioned, there's no cost for the contingency-based litigation up front. So in other words, we're putting the time and the effort and the filing fees and all that we talked about into it, and then we split the net proceeds 50-50. All right, so let's open it up for questions. Some of you on today's training are debt buyers already with us. So this is the formal rollout, so you know how the debt buyer contingency-based litigation program works. Hopefully you're in a better position now to decide, yes, I want to use this tool to collect the AR, or no, it's not what I want to do. You want to do something else, that's fine. Others of you are not debt buyers yet, but needed to understand how buying assets, defaulted assets, can make you money. And we've used some examples and I think in quite a bit of detail describe the process. So let's open it up for questions before we close today. So Alfred, Griffin, Joseph, Lon, Pauline, Ron, we got a lot of attendees today, which I'm thankful for. What questions? All right, and so Alfred's asking, and that's correct. So what I meant to convey, and it's my fault if I didn't, is that in the new debt buyer contingency-based litigation program, business paralegal is going to be responsible for all of these steps. So the debt buyer doesn't have to do any of it. So Alfred's question was quite simple. Who's responsible with post-judgment collections? And the answer is business paralegal will do it. Now, we may bring in other resources. We have a number of law firms on retainer, and there's other third-party firms, but it's a turnkey program, because what we found is most of our debt buyers, this is not their business. It's not their passion. They don't get up in the morning excited about buying and selling and collecting off debt. It's just not their thing, right? They're worried about other issues. So this has been structured as a turnkey resource. Thank you, Alfred, for that. Anyone have any questions on the collateral support program, which we kind of gave just a cursory overview on its function? Of course, on Business Paralegal, the collateral support program is a page, so you can learn more if you'd like. I think there's a video there as well. But today's primary goal was to, in some detail, go through how the new debt buyer contingency-based litigation program works. And so you can make an educated decision. So essentially, we're buying, if you wanted to frame it a different way, we will buy debt from you for 50 cents on the dollar. We'll go do all the time, spend all the time and effort and resources to go litigate it, and we both get paid. So if you look at it from that perspective, that's remarkable, right? So being able to receive 50 cents on the dollar, predictably, could be more, could be less, but 50 cents on the dollar from non-performing debt is crazy good. All right, so Griffin asked, when's the deadline to come up with the money? Well, Griffin, I think you've mistaken. There is no upfront cost for this, right? That's the whole point, is there is no upfront cost. We foot the bill. We spend all the money, the time and energy to collect this money for you, Griffin. So we're not trying to sell you anything. You're not paying anything for this up front. We're going to do all the work, incur all the expenses, and then we're going to split the proceeds 50-50. Sorry for the confusion on that, Griffin. Kiana says she has a private money lender, credit restoration, paralegal, investigation background. Awesome, awesome. We should be collaborating, Kiana. Hannah asked, so Hannah's already one of our debt buyers. She's in the collateral support program. So, and so Hannah's doing a great job of illustrating to me I didn't make the call to action clear enough. So the call to action is, if you are a current debt buyer and you want to participate in this, you need to let me know, because what we need to do, which is summarized down here, is we need to assign the debts so we can work on them. And so you need to let me know. We got a simple one pager. We can assign the debts, and then we can proceed with the process, Hannah. If for those of you that are not debt buyers yet, of course, the first step would be to acquire the debt through the collateral support program. Then we can move to liquidation. You can't liquidate something you don't own, not legally. Any other questions, comments, concerns? We ran long today, but this is a really advanced topic. And so as you can look at it from, we'll close with this. You can look at it from a few different perspectives. Most small businesses have a collateral shortfall, which impacts their access to capital. You and I have a resource. You can be a debt buyer. You can buy the portfolio. You can sell it to small businesses, and you can mark it up, right? That's awesome. And then furthermore, then we can help the debt buyer, the end owner of that, liquidate through litigation. But absolutely, and that's what Joseph's asking, can he make money from this? I love Joseph because he's always asking, how does he make money? And he makes a lot of it. But yeah, so you can be a debt buyer, you can buy portfolios, we can liquidate it for you, or you can resell it. I mentioned that was one of the ways to liquidate. So the main ways to liquidate debt would be collect off of it internally or externally, litigate it, which we've just talked about, or resell it, right? And reselling means that you could buy it at wholesale, sell it at retail, and make a margin off of it. And then we can help the end user, your client, liquidate it through litigation. So everybody wins. All right, well, we covered a lot. Thank you for your time. Let us know if there's questions, and we'll see you back tomorrow morning. Have a good day.